Blake Lively gets a whole bunch of her claims dismissed, but declares victory and vows to go on. How will it all end? Who knows? May it please the audience, I'm Rich Schoenstein. This is So Sue Me, and on this edition, we're going to talk about the lawsuit they said you couldn't get me to talk about, Blake Lively versus Justin Baldoni, and a whole gaggle of corporate entities sucked up in this slobberknocker of a lawsuit pending in the United States District Court for the Southern District of New York, in front of Judge Louis Lyman, who I am very familiar with, as I've had a couple of trials in his courtroom in recent years. I'll start with this. Last week, we got this decision, an order and opinion on pending motions for summary judgment and judgment on the pleadings. Those essentially are motions to dismiss claims before they go to trial. This case has been pending for a while, since at least early last year. And we already saw the dismissal of a bunch of the counterclaims by Justin Baldoni, so it was a one-sided case. And this decision from Judge Lyman takes on what's remaining in the case, Blake Lively's causes of action. And to cut to the chase, because it's 152 pages long. That's the decision here. It goes on and on and on. And I thought, maybe we'll scroll through the decision. We'll take a look at the legal arguments. We'll talk about the claims that are in, the claims that are out, the legal reasoning. And then I thought, why would I do that to you? Why would I sit here and scroll through a 152-page legal decision to go over it? It's a very good judge. The reasoning is very good, but I couldn't make it through this whole decision. It's just very hard to get through. And we don't really care what was said. What we know is this case has been litigated. This, by the way, was not the first complaint. There was a complaint. There was an amended complaint. This was a second amended complaint that was filed late last year. The second amended complaint was itself 146 pages, contained 13 different causes of action, lots of factual allegations. I mean, you know you're in trouble when the complaint has an index. A complaint is supposed to be a short and plain statement of the dispute. So when you start off with this convoluted index and an introduction and this big block quotation and then a whole introduction section, you know you're in trouble. You know you're in trouble. We have a lot of cut and paste images in this complaint. You'll see there are cut and paste text exchanges all over this complaint. And again, I thought about, let's go through the allegations in the complaint, but why would I bother you? You're on page 21 before you even get to a description of the parties, which is usually the first thing that happens in a complaint. So this thing is just, you're on page 24 before you get to jurisdiction and venue. So this complaint was very well thought out, well written, and comprehensive. It was, again, the second amended complaint. This was supposed to be the best shot that Blake Lively and her lawyers had at stating a claim against Justin Baldoni. I'm going to cut right to the chase here and tell you what's in and what's out of this case. You scroll down past all this stuff, you get to her causes of action. Now, the first cause of action is for sexual harassment in violation of Title VII under federal law. That's out. The court ruled that she wasn't an employee, she was an independent contractor. Title VII didn't apply, and even if it did, there were other problems. So Title VII sexual harassment is out of the case. The second cause of action, retaliation under Title VII, also out of the case. The third cause of action, sexual harassment under California law, the FEHA, that's out of the case. That's the Fair Employment and Housing Act in California. Judge thought there was not evidence of that. So the first sustained cause of action is the fourth cause of action, retaliation. And I'm going to talk a little later about a retaliation claim versus a discrimination claim and why one is much easier to sustain than another. Then there's a retaliation under the California Labor Code. That's out. A failure to investigate or remedy harassment claim under California law, that's out. Aiding and abetting retaliation, that is it. So that drags some other defendants in here with the principal defendants on the retaliation claim. So that expands a little bit the defendants. But notably, there's no claim against Justin Baldoni individually remaining in this case. Eighth cause of action for breach of contract on the actor loan-out agreement. That's the main agreement concerning Blake Lively's participation in this film. That's out. I think the court found that the contract wasn't even signed. It wasn't a final contract. Now, there's a ninth cause of action for breach of contract under something called the contract rider agreement. That's the agreement that was entered into. She had left the film for a while and came back for reshoots or something, and they negotiated an agreement. She raised some of the objections that have come up in this lawsuit, and that cause of action for breach of this contract rider agreement is in the case. So this ninth cause of action is in it. It's against It Ends With Us Movie LLC and Wayfarer, which I gather is the studio. 12th cause of action. By the way, the numbering on these causes of action, I don't know why we go from 8 to 9 to 12. I don't know. It's some careless errors in this complaint, but this false light invasion of privacy claim, that's out. Sexual harassment under the California Civil Code, that's out. Defamation and defamation per se, out and out. All this stuff is out of the case now. Civil conspiracy against all defendants, out, gone. No conspiracy, no defamation, no conspiracy, no claim against Justin Baldoni, just no discrimination, no hostile work environment. The only claims that remain are these retaliation claims asserted against a few of the corporate entities. So what did Blake Lively have to say about all of that? Did she go back and lick her wounds? Nope, she declared victory. She put out an Instagram post saying, "I'm grateful for the court's ruling, which allows the heart of my case to be presented to a jury next month, and for the ability to finally tell my story in full at trial. For my own sake, but also for those who don't have the same opportunity to, many of whom I have known and loved deeply in my life, and the countless I'll never know." And then she has a lot to say about why it's a retaliation lawsuit, in all caps and bold, for privately and professionally asking for a safe working environment for myself and others. And then she goes on to say, don't be distracted by the digital soap opera. Actually, she goes on to say the court decision allows her claims to go forward. And then she says, don't be distracted by the digital soap opera. And she talks about the problems on the digital space, that people are being bullied in social media and elsewhere, and particularly women. And I want to be clear, I think that's true. I think there's way too much bullying on social media. I think there's a big problem with the way we use social media, what we do on it, how we attack people. I don't think that's what this lawsuit is about. I mean, that is an important cause, but she's trying to glom onto it in what essentially is just an ego fight between her and another actor over a mediocre movie that's long forgotten and didn't do very well, in the box office, and didn't rate very well. In any event, they're still fighting over it. I don't think that has a lot to do with digital attacks against women as a general matter. I just don't. If you read the complaint, if you read the pleadings in this case, if you take a look at some of the stuff I'm not going to bore you with, this is really about a movie production and a fight between the two main actors in the movie. And that's all it is. And to call it something else and try to claim you're out doing social justice, I don't know. I mean, I guess I understand if some people think maybe she's going to accomplish some good in this lawsuit. I'm not so sure I'll see it. But the idea, and look, the last thing I want to do is come on and agree with Piers Morgan, but the idea that she's grateful for the court's ruling, I guarantee you her side was miserable about the court's ruling. If you lose 10 of your 13 causes of action, that is a loss. And if you lose your discrimination claim, your defamation claim, your conspiracy claim, don't come back and tell me, oh, but the heart of my case survived because the heart of my case was retaliation. Well, then, why was the heart of your case the fourth, seventh, and ninth causes of action? The heart of my case is usually the first cause of action and second. So I don't know why these retaliation claims would be the heart of her case. Nobody believes that. And let me talk a second. Retaliation claims are easier to sustain because to prove discrimination or hostile work environment, you really have to prove that those things occurred, that you were discriminated against because of your gender, that the work environment was illegal and inappropriate. You have to show that with evidence. The thing about retaliation is the laws in this country, including California law, protect someone who complains about discrimination or a hostile work environment, even if there was no discrimination. Meaning, as long as you had a good faith basis to complain about it, you can't be retaliated against. And that's why a retaliation claim is always easier to prove than an actual discrimination claim, because it doesn't matter if there was no discrimination. If you believe there was discrimination and if the employer took it out on you for raising it, you have a retaliation claim under federal law and under a lot of state laws. So that claim is going to go forward. And if you helped that, if you participated in that retaliation, you can be on the hook for aiding and abetting. And the one contract claim that survived, that's because the contract said there can't be any retaliation. So it's really just another basis. There's the California law basis and the contract basis, two different sources of protection for her against retaliation. And the judge felt, going through the record, that there was enough evidence that she was retaliated against for raising these concerns. And that's the claim that's going to go to trial. It's still an important claim. Like, retaliation is totally inappropriate. And it's right that there are laws against it, and those laws should be enforced. But that's not the heart of her case. It was never the heart of her case. The heart of the case was that she was discriminated against. The heart of the case was that it was a hostile work environment. The heart of the case was conspiracy and this other breach of contract and defamation. Those were the heart of the case. So she has lost a good deal of the bases for her claims, and that's just it. It's still scheduled for trial, apparently, starting next month. Now, let's take a look at the docket. All right, this is the federal docket for the case, which tells the story procedurally as to what's happened. So if you've never seen this before, just take a look. Like, here's the plaintiff. Here are all of the lawyers representing the plaintiff. You just see them named one after another. By the way, these are ginormous firms here. She's got Monet, Phelps and Phelps. She's got Wilkie, Farr and Gallagher. She's got Haynes and Boone in Texas. Those are prominent, large law firms that really should be able to number a cause of action consecutively. But I'm sure they're doing a good job. Then you have a consolidated plaintiff. That's really the defendant here, Wayfair Studios, but they had cross claims. They, too, are represented by very large, very well-known firms. They have good representation. Justin Baldoni has the same lawyers. So if you look at this docket, we're just pages and pages just seeing who the lawyers are. Just seeing who the lawyers are. We're still just seeing who the lawyers are and who all the parties are. That's how big a case this is. Okay. Now, when you get down the action, so it was filed December 31st, 2024. I said early last year. It was actually last minute the year before that. And if you look, you will see that in that relatively short period of time, there are 1,275 docket entries. And if you're wondering if that's a lot, yes, that is a lot of activity on a docket, particularly a civil case that's only been around for a year and a half, less than a year and a half. To have 1,275 docket entries is crazy. I want to highlight this last one, though. There was the opinion and order that came in last week, and they apparently had a status conference last week. They have some other conferences on the docket. But today, as I'm recording this, the magistrate judge was going to have telephone conversations with both sides about settlement. So you may recall that there was, I don't know, a month or two ago, there was mediation in this case. There was activity down at the courthouse. That's all in private with the magistrate judge. We don't know what happened. We only know the case didn't settle. Well, now the magistrate was going to follow up with both parties, and that's perfectly normal. Summary judgment has been decided. The case has been whittled down to something narrower than it was to begin with, and settlement positions may have changed. What the plaintiff is willing to accept, what the defendant is willing to pay. Also, as you get closer to trial, you always have a little activity around settlement, right? One of the best times to settle a case is right before you go to trial, because I guarantee you, trying this case is going to be, I don't know, well over $1 million in legal fees combined, maybe multiple millions. I mean, it's going to be expensive when you look at the number of lawyers involved, the kind of firms they look at, how long this trial might go on. It's in federal court. They're going to bust out all the stops. It's going to be a very, very expensive trial. And it would probably make sense for the parties to settle if they can come up with some common ground. Now, this case is not just about money. It's about public relations. It's about who gets credit for a movie. It's about all kinds of other stuff. I don't know if that helps or hurts the prospects of settlement, but it's relevant to the prospect of settlement. They're fighting, as I always say in these celebrity cases, they're really fighting two battles. One is in the courtroom, where they're trying to prevail on their claims or their defenses, and then there's this public media thing. Blake Lively put out an Instagram post following the summary judgment decision. You would never let a client put out a public statement about a summary judgment decision unless that client had to do it because they're famous and the case is being covered. And then it makes sense. And then you can't tell your client, keep your mouth shut. You're going to end up getting cross-examined on the stand, so we don't want you saying anything. You have to let her speak because she has this whole public relations element of this case. So I think the case might still settle before it goes to trial. There seems to be a magistrate judge working on that. And again, the case is a lot less than it was to begin with. I'm sure it's still going to be heavy in terms of evidence and lots of witnesses and lengthy proceedings, but it's just a retaliation case now. It's not about a lot of this other stuff. I'm not sure that she'll get to put on the full scope of evidence she otherwise would have been able to put on. Okay. So there you have it. That's the latest in the Blake Lively, Justin Baldoni, Wayfair Studios civil litigation. If you are following that case closely, get a hobby. Just find something else to do, because that is a rote civil controversy. It's just not all that interesting between a couple of actors who think they should have had more credit. Anyway, thank you for watching this report, and I'll be back with more if it happens or on other topics soon. Don't forget to like this video. Don't forget to subscribe to our endeavor here. For now, we are adjourned.